Oh, hey, folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, when should you create your special needs trust, also known as a supplemental needs trust? The answer typically is the following. If you're thinking about it, or if you do have a loved one and you're not aware, and that loved one is a special needs person or someone who developed a disability during their lifetime, they may not have necessarily been born with a disability, but they could have developed a disability or experienced a disability due to an accident or a medical situation. And if that person is either receiving government benefits, which we refer to as means tested public benefits, such as Medicaid, Social Security benefits through the Social Security Administration. SSI is often a very common one for a disabled person, different than SSDI, which is an entitlement. That's not a means tested public benefit. That is someone who worked enough quarters in their lifetime and then became disabled later in life and they can no longer work. They typically receive SSDI. SSI is reserved for people born with disabilities or someone because of a significant disability, physical, mental, whatever it may be, they're not able to work. So as they become an adult in life, they need assistance from the government with means tested public benefits such as SSI. And if that person's a loved one of yours and you would like to leave them something someday in your trust or treasure chest, it's essential that you create the proper special needs trust in your plan. The recommendation, folks, is you create a third party supplemental needs trust for your loved one. Write that down. Extremely important. Third party supplemental needs trust for your loved one. In your trust. In your trust, folks. Because a third party supplemental needs trust does not require government payback. I'll repeat that. Does not require government payback. And so long as that third party supplemental needs trust is drafted properly, T's are crossed, I's are dotted, your loved one will not lose their government benefits. They will be able to resume their means tested public benefits, SSI, Medicaid, things of that nature, because they cannot go over $2,000 in assets. If they do, in an inheritance, that'll put them off their government benefits. It'll jeopardize their government benefits. That'll be devastating for them, okay, in the services that they were receiving. So third party supplemental needs trust, write that down, take action, meet with your state elder law attorney or special needs trust attorney and create that third party supplemental needs trust. And the nice thing, folks, you can create that within your trust that says when mom and dad are gone, Bill and Mary are gone, their children, Mo, Larry, and Curly. Say, for example, Curly's a special needs trust person. Curly does not receive an outright hands distribution in the palm of his hands. No, no. You create a third party supplemental needs trust for Curly. You name Mo as his trustee manager to manage that money for his benefit, to enhance his quality of life, for his extras, things the government money would not pay for. That way he gets his cake and eat it too. He can continue to resume his government benefits and also receive his inheritance in that third party supplemental needs trust to enhance his quality of life. Needs to be done before you check out, folks. That's really, really important. That's something you cannot do after you're disabled or gone, right? You need to create that third party special needs trust or supplemental needs trust when you're alive and well. So now's the time to do it, to answer your question. Because the alternative is if you don't take any action, if you sit on your hands and you procrastinate and you get hit by the bus of life tomorrow, and your loved one, whether you have a will or a trust or not, the laws of intestate will say who your beneficiaries are. I've seen cases like this. Mom and dad pass away. Their son or daughter is a special needs trust person. They either have a will or no will. That child receives your assets as their inheritance because they're your heirs at law. They're on government benefits. Immediately, it's going to put them over the $2,000 threshold. It's going to put them over asset. They're going to lose their government benefits, or at minimum, they're going to have to spend down that money privately and pay for all their care until they get back under that $2,000 threshold, which is the current number for means tested public benefits. And then their only strategy they have available to them to continue receiving their government benefits, they need to create a first party special needs trust, a first party special needs trust, which is entirely different than a third party supplemental needs trust. Third party, again, no government payback. The strong distinction is first party special needs trust requires government payback. So whatever money's left over in that trust account, when that special needs trust person passes away, who gets it? Not your family, the government, because first party special needs trust requires government payback. So folks, write it down, take action. Hopefully you found this video helpful. If so, post a comment, post a question, because a member of our team will get back to you as soon as possible. Be sure to click the subscribe button and the bell, because we will keep you updated with other important elder law and special needs trust planning strategies. Folks, strongly recommend also pick up a copy of my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, because we can work together to slay that four-headed beast, that metaphorical four-headed beast together. Folks, thanks for joining us here today at elderlawcare.com.